Greetings, everybody. Tonight we're going to be talking about copyright and work for hire. And I think this is one of the most important events that I've ever done. And I've had Paul Levine come in on multiple occasions to actually address this particular topic, specifically because he is a widely respected leading entertainment attorney, and he has a very specific background in working with writers and screenwriters and producers to secure and protect intellectual property rights. And there's nothing more important than understanding the fundamentals of intellectual property right protection, registration, and also the fundamentals of work for hire. If you happen to be a writer, screenwriter, filmmaker, etc., or an artist or a photographer, specifically because what you're selling is and what you're licensing when you sell your work are your intellectual property rights. So if you don't know how to protect your work, and you don't know what people are buying when they do a work for hire agreement, you can find yourself in some very hot water. And a lot of times you can create sort of work that is so bastardized or so ambiguous that it becomes almost impossible to easily sell. It's kind of like a child with too many parents or not enough. So with that in mind, Paul, do you want to talk for a few minutes about the work that you've done over the years and from whence hails your background in entertainment law and specifically working with writers, screenwriters, and filmmakers to protect their work?
Sure. So I'm Paul Levine. I thank you, Nancy, for having me. I came here for law school at USC in 1978, grew up in Canada in Montreal. I had a Jewish mother, so I only had two choices in life. And so being a doctor was out of the question. So I said, if I've got to be a lawyer, I might as well do something fun like entertainment law. And so applied to USC and UCLA and a whole bunch of other places and decided on USC. Graduated in 1981. I am now an adjunct professor of law at USC Law School. 40 years later, they finally asked me to come back again. The very first job that I had fresh out of law school was at a small firm in Century City. And we had three clients that kind of shaped the rest of my career. The first was a book publisher called Price Stern Sloan. Roger Price created Mad Libs. Leonard Stern created TV shows like The Honeymooners and Get Smart. And Larry Sloan was the business guy. He was the brains of the operation. And he literally taught me book publishing. So I was very lucky because most lawyers, most entertainment lawyers focus on motion pictures, television, or music. I got to focus on books. And that was a terrific background, which served me well for the rest of my career. The second client that shaped my career was a guy named Jack Kirby. Jack created Captain America, Spider-Man, Incredible Hulk, Fantastic Four, X-Men, on and on and on. And so I got heavily involved in comic books and graphic novels and still am to this day. I still represent Jack's estate and lots and lots and lots of other people in the comic book world. And the third client was a nudist colony. We did First Amendment law. So back in the day, First Amendment law was representing pornographers. Pornography back then consisted of books and magazines. If you wanted to see a porn movie, you went to the Pussycat Theater on 2nd Street in Santa Monica. There was no such thing as video cassettes or anything else back then, or no streaming, no nothing. And so that was a noble pursuit back then to do First Amendment law. Today, I'm not so sure. In any event, because of all of that, I had to learn, of course, copyright law, because copyright law is the foundation which underlies all of entertainment. And so that's what we're going to talk about tonight. We're going to talk about every aspect of copyright law that we can possibly squeeze into an hour and a half to lay people. And all the participants here should not feel bad, because I promise you, you're no smarter than the law students that I taught at USC Law School, who have no clue about copyright law either. The treatise on copyright law is a 7-volume set. each volume consisting of about 500 pages each. And it is by far the most complicated in some ways, and in some ways the simplest legislation ever enacted by Congress. My old boss used to say that copyright law was the greatest piece of self-help legislation ever enacted by Congress, because unlike trademarks where you have to apply to the government and the government issues you a certificate once it approves your application, and unlike patents, the same thing where you have to apply to the government and the government issues you a certificate after it approves your application, you have a copyright in your work at the moment you create it. You don't have to do anything in order to own a copyright in what you create. So let me give you before we get into the questions, Nancy, let me give a very brief overview of basics of copyright law. Copyright protects original works of authorship. And each of those three words are really important. Work, original, authorship. So let's first of all talk about original. Original means two things. It means that it originates with you. You own it, you created it, it's yours. Original also means that it has some element or some minimum amount of originality. That it's not simply, for example, a phone book with a list of names and numbers. It has some creativity to it. Not a lot, but something. Which is why, by the way, recipes aren't protected by copyright either, because there's just a list of ingredients. What you do with those ingredients that's protected by if you give instructions, those instructions are protected by copyright, but the list of ingredients is not. Original work. A work means that it's something that's fixed in a tangible medium of expression, which means that it can be perceived by the senses. You can read it, you can hear it, you can watch it, you can perceive it with your senses. It's fixed in a tangible medium of expression. I used to give an example of something that was not fixed in a tangible medium of expression and therefore was not protected by copyright, but now that has changed. Choreography. Up until 20 years ago or so, choreography was not protected by copyright because there was no way to fix it or record it in tangible medium. A recording of a dance performance, that performance recording is protected by copyright, but the choreography itself wasn't protected by copyright. And some choreographer, I don't know who it was, invented a system like the musical note system of recording musical notes. Somebody invented a system of recording dance moves, like pirouettes or pliés or whatever ballet movements and other dance movements there are. There's apparently a system of recording those dance movements, similar to the musical notes on a page. And so now copyright in choreography exists because it's now fixed in a tangible medium of expression. Original works of authorship. Authorship, and that's what we're going to talk a lot about tonight. Either you own it because you created it, or you did it for somebody else. And the mechanics of how you did it for somebody else, whether there was a written agreement between you and that somebody else, whether it's a motion picture studio or an independent producer or whatever, I'm talking about work for hire. How does one, how does a work for hire get created? Either it is authorship because you are the author, because you created it, or the company or the person who employed you as on a work for hire basis owns it, if the proper hoops have been jumped through in order to create a proper work for hire. Unlike most areas of the law where there's gray, the work for hire law, in terms of what is required to create a work for hire under the Copyright Act, is pretty straightforward and pretty black and white. There's not a lot of wiggle room. So I'm happy to get into it. Okay, so with that introduction, let's go through your questions.
All right. I guess one more thing I want to mention. Did you mention the Hearst Corporation?
Did I mention what?
You worked for the Hearst Corporation, yes?
Oh, Hearst, yeah.
You should probably put in
After
the
the
part
law
where you
firm, I worked for
film
Warner
company.
Brothers Television. I worked for Hearst Entertainment. At Hearst Entertainment, I had the boss from hell, and I swore I would never have a boss ever again. And so I've been a solo since 1992. In 1995 or so, I also opened up a literary agency, selling books to book publishers and then turning those books into movies or television programs when that's appropriate. I spend 75% of my time as a entertainment and other kinds of lawyer, and 25% of my time as a literary agent selling books. The latest book that I just got published, that I sold last year, is the biography of Trader Joe Coulombe, called Becoming Trader Joe. It was just published yesterday by Harper Leadership. You should all go out and buy it. It's a wonderful book.
That's very cool. So the only reason I mentioned that to folks is because for people that are filmmakers and who are wondering, first of all, how to negotiate rights sales, and for people who are thinking about doing biopics, or people who are thinking about doing stories based on a true life story, those kinds of things, setting life rights purchases, and also other details, they need to know that that's something that they need an attorney for as well. And we'll talk about that as we go through the questions.
Yes, so, indeed. Hearst Entertainment owns the Lifetime, or used to own the Lifetime channel. I probably did, no exaggeration, 150 movies for television during the 2 years that I was at Hearst Entertainment. So that's all of the legal work with the subjects of the movie, with the producers, with the actors, all of the legal work, what lawyers call production legal, on all of those movies for television. And they were big back in the 90s. This was 1990 to 1992. Each of the, not just the Lifetime channel did hundreds of them, but each of the networks did 20 movies for television a year apiece. So there was 60 movies for television for the 3 networks, and then another 100 or so for the Lifetime channel.
And none of them were flattering about people, I'll bet. Anyway, so right, in other words, they were doing a lot of tell-alls and true life stories, and based on, ripped from the headline stories, I recall.
Yes.
So
woman overcomes, for Lifetime channel, woman overcomes great odds and goes on to fame and fortune.
Right, exactly. So you may want to sit back just a little bit so that you sort of.
Okay.
So the next thing, the first question I have, you've already addressed the first one, sort of to some degree, which is, when is work registered by copyright?
Protected by copyright.
Right.
Work is protected by copyright at the moment of its creation.
Right.
In the language of the statute, it's one of my favorite words in the English language. Copyright inheres in a work, is inherent in a work at the moment of its creation. You don't have to do anything in order to own the copyright in your work.
Right.
Whether it's a sculpture or a painting or a musical composition or whatever it is, as long as it's a original work of authorship, you own it at the moment you create it.
So, and which brings us to the second question.
Hi, Christine. How you doing? I'm sorry, I just looked at your chat.
Well, if you watch the chat, we're going to be real trouble. Hi, yeah, actually, although I always say hi to Christine when she comes on too. No, who doesn't love Sherwood Oaks? So the next question is, people register stuff at the Copyright Office. If they have a copyright automatically, then why do they have to register at the Copyright Office, or why should they register at the Copyright Office?
Why should they register at the Copyright Office? A long time ago, the founders of the original first Copyright Act decided that to give people incentive to register their work for copyright, the whole idea was to create what is called the Library of Congress, which is a library of every work created in the United States, whatever it is, whether it's a book or a musical composition or a piece of artwork or whatever it may, a motion picture, a television program, a documentary, whatever it is. The whole idea was to create a compendium of every work ever created by Congress, but by people in the United States. So Congress, in order to incentivize people to register their works for copyright, gave people two benefits to encourage them to register their works for copyright. One is the ability, if you have to sue somebody for copyright infringement, the ability to collect what are called statutory damages instead of actual damages. For a beginning person who creates something for the first time, they have no track record. Let's say it's your first book. And you don't have a track record. You can't say that, you know, on my previous book, I made so much money, or my first motion picture, or my first whatever it may be. And so therefore, when you have to sue somebody because you've been ripped off for copyright infringement, you can't point to the actual damages, the damages that have actually been caused by the infringement. So therefore, you instead can elect, and you can elect this anytime up to the time the case goes to the jury, you can elect, instead of seeking actual damages, you can seek statutory damages, damages under the statute. And those can range from $150 on the low end to $150,000 if the jury and the judge find that there was willful, knowing, and deliberate infringement. So willful infringement is things like selling a counterfeit DVD of a movie that hasn't even been released yet. Nice and simple, and straightforward, and slam dunk, you get $150,000. Innocent infringement, very quickly, George Harrison wrote a song called My Sweet Lord. The owners of the copyright in the song He's So Fine, the Isley Brothers, sued George Harrison, saying the melody, not the lyrics, but the melody of that song was identical. Those three notes, he's so fine. I'm not going to sing because I can't sing. My sweet Lord. Those three notes were identical. No question they are. So when George Harrison gets up on the witness stand, George Harrison testifies that, sure, I heard the song He's So Fine by the Isley Brothers, along with thousands and thousands of other songs, including some songs by a group called the Beatles that I was part of, etc. And I didn't set out to rip off the melody of He's So Fine. It just so happened I used the same three notes when I was writing My Sweet Lord as the Isley Brothers did in He's So Fine. Jury believed him, awarded $150.
So one thing you get is the statutory damages, and what's the second benefit?
The second benefit is attorney's fees, something near and dear to the hearts of lawyers everywhere. So under our system of justice, normally when a plaintiff sues a defendant, plaintiff pays his or her own lawyer, defendant pays his or her own lawyer. Regardless of who wins and who loses the lawsuit, each side pays their own lawyer. However, if there's a contract that says, in the event of a dispute about this contract, the prevailing party, the winner of the lawsuit, the prevailing party shall recover attorney's fees from the losing party, that changes the normal way of doing things. By the way, the United States is the only civilized country in the world that has our system of each side paying their own lawyer. Every other country, prevailing party gets attorney's fees. We don't. So, for example, if you get into a dispute with your landlord, you have a lease provision in your lease that says if landlord has to sue tenant for rent, or tenant has to sue landlord for a breach of habitability or whatever, whoever wins the lawsuit gets attorney's fees from the other side. So that's by way of a contract. The second way that you can change the normal each side pays their own lawyer is by way of a statute. And in this case, the copyright statute says, if you register your work prior to the date of infringement,
Mm-hmm.
you can collect attorney's fees if you win your infringement lawsuit.
Cool. So when you hit the table like that, it makes it so we hear that bumping sound.
Sorry,
But anyway, I know you're very emphatic. That's an
I'm
important.
emphatic. I'm trying to.
No, you're doing
As
great.
you can see, even though I'm not Italian, I talk with my hands.
No, that's- so
Yes.
it's
So again, so the whole thing is, if you want to get the benefits of the Copyright Act, you need to register your work for copyright as soon as it goes out into the world.
mm-hmm.
As soon as you've written a book and you're starting to send your manuscript to potential publishers or potential agents, as soon as you've written your film script and you're trying to get an agent to shop your script to Hollywood, as soon as you've created your musical composition and you're sending your demo package to a record label, whatever it is that you're doing, you need to spend the what is it, $45 or $55? Back when I started, it was $5.
Those are the days.
I'm old. Anyway, you need to spend the money and register your work for copyright. And you need to register it with the Copyright Office. Do not register your scripts with the WGA. I love the WGA. I think they do screenwriters and TV writers a great disservice by confusing them into believing that registering with the WGA is the same thing as registering with the Copyright Act. It is not. The Writers Guild will take your money, they will put your script in an envelope and put it in a safe. 5 years after you register it, they will burn it or shred it. They will keep it for 5 years. That's all they do. You don't get any of the benefits of the Copyright Act that I talked about. You don't get the statutory damages or attorney's fees if you have to sue for copyright infringement. And it's the same money. So do not register your script with the Writers Guild. Do register your script with the Copyright Office.
Right. So so I'm going to so for people that are asking questions, you can put them in the chat. And at the end of the event, if we haven't answered them, we'll answer them. But I'm going to continue on to ask Paul to answer as many questions as possible. And in most of the cases, the topics that questions that you're asking are questions we will be absolutely going through. So so don't register at the WGA, do register at copyright.gov. The next question, and register the work before you start sending it out, before you start sending it.
You don't know when you're going to get I'm answering your third question. Right. You don't know when you're going to get ripped off. So an ounce of prevention is worth a pound of cure. Right. Don't try to scramble and have to register your copyright after you get ripped off. Right. And have to pay for an expedited registration of almost $1,000. As soon as it goes out into the world, as soon as it leaves the confines of your home and your friends and your family, that's when it's prudent to register your work for copyright. It's as simple as that. And it doesn't matter what it is: a book, a movie, screenplay, a stage play, a film, a photograph, whatever it is that's protected by copyright, register it, and register it using the appropriate form. If it's a work of text, use the TX form. If it's a work of the performing arts, like a motion picture, or use the PA form. If it's a screenplay, you can use either one.
Really?
You can use either the PA form or the TX form. The Copyright Office doesn't care. If you end up using the wrong form, the Copyright Office will tell you, and they will ask you to use the right form. But they won't charge you again.
They actually do call you. I don't know if you've ever actually had that. Just for people.
Yeah, they'll call you, or they'll send you an email, or both.
Right. They're very nice people, actually. When you're
right now, they're all working remotely because the Copyright Office has been closed for over a year.
Right.
The one bad thing about that, or it's nice to have them all working remotely, but the bad thing is you can't do a copyright search of pre-1978 works. The Copyright Act was changed in 1978 dramatically. So everything post-1978 is all digital, easy to search. Pre-1978, you literally have to go to the library card catalog. Remember a card catalog in a library? So right now, the Library of Congress is closed.
Hmm.
So if I want to search who owns the copyright in Gone with the Wind, I can't do that right now because I can't go to the Copyright Office and look in the card catalog,
Hmm.
or have somebody like Thompson CompuMark or one of the copyright search services do that,
Hmm.
which is a huge problem. Hopefully, in the next few months, that'll change.
That's cool. So if when somebody's registering a work that's got words and pictures combined, does that do you register the words and pictures separately, or how does that work?
One form, the TX form,
TX form, cool. Even though it's got pictures.
even though
Um,
it's got pictures.
and that's assuming that you own the pictures,
That's assuming you own the pictures.
right? So let's take quite a quick deviation and talk, because we're going to go back and dive into the rest of the questions. But I want to now have you talk, if you don't mind, about specifically work for hire and about
Okay.
why it's so important, so important to have a written agreement.
Okay. Well, there are two ways that a work for hire gets created
Mhm.
in the entertainment world. One is, as you said, Nancy, by way of a written agreement, which has to be uh, drafted, entered into, and signed before the work commences. So if I'm writing a children's picture book and I'm hiring Nancy as the artist to do the illustrations, I have to have as if I want to own the copyright in the illustrations that Nancy creates based on the characters that I write about in my picture book, I have to have a written agreement with Nancy, which specifies her compensation, just like any other agreement, and specifies that I own the results and proceeds of her work as a work for hire. And that agreement has to be signed before Nancy commences the work. This is what I was saying before. This is not a gray area. There is no wiggle room here. Either you're pregnant or you're not. Either the agreement was signed and entered into before the work commenced, or it wasn't. If it wasn't, it's no good.
Mhm.
There's no getting around it. So if you're going to have somebody, some third party, create something as part of your work, you're a sculptor and you do metal work, but you don't do ceramic work, so you hire a ceramicist to create the ceramic portion of the piece that you want to put into your sculpture. Whatever it is, you need to have a written agreement with that person before that person starts the work.
So,
So that's one way a work for hire is created.
mhm.
The other way is if I employ you. You have been my employee for a long time. I have you're my I'm Warner Brothers. Warner Brothers has employed um, writer Joe or writer Jane to write episodes of a TV series for Warner Brothers. There is an employer-employee relationship, and therefore anything that the employee creates while employed, the employer owns.
Mhm.
The question of when there is an employer-employee relationship is a question of state law.
Mhm.
Under a case called CCNY versus Reed, the United States Supreme Court, about 20 or so years ago, decided to punt and say, we're not going to decide when an employer-employee relationship is, because every state is different. We're going to say, whatever state you're in,
Mhm.
that state's law on whether there's an employee or employer relationship governs. Here in California, we now have AB5.
Mhm.
So one of the huge issues about independent contractor versus employee in the entertainment world, never mind the Ubers and the Lyft drivers and all the other stuff that's going on in Sacramento, is when is there an employer-employee relationship and when is somebody an independent contractor? I can't answer you.
Mhm.
If the ABC test decided by the Dynamex case and AB5 continues on, we got huge problems coming
Mhm.
on when somebody's an employee and when somebody is an independent contractor. We'll see how it all shakes out.
So, but the important thing for people to understand is that so I always think about things from the writer's perspective or from the creator's perspective. If I've created a piece of work and then I end up working with a producer and they say they make trying to make me sign a work for hire agreement after the fact, then it is
It'll
after
get,
the fact.
you can challenge, you as the creator will be able to challenge that, and there is no work for hire agreement, and therefore you own whatever you created and not the producer.
Right. And also it
Okay.
means that if you are a filmmaker and um, you're acquiring a screenplay for somebody, or you've acquired a screenplay for somebody, and now you're hiring a second writer to come on board and make edits to it. So you have to have agreements that you need to work with an attorney to make sure that all the agreements are in place for the original work that you're modifying, because that's some sort of purchase probably, and or whatever, something's going on with that. And then you also, for this guy that you're telling what to do, you need to have an agreement with him because he's modifying the work. So
Yes.
you need to work with an attorney on these issues because they're core to the content that you're creating, and to your ability to sell it going forward, right?
Mhm. Yeah. So there's another way besides the work for hire um, thing that we've been talking about. There's another way that studios and production companies acquire the copyright in something that was created. You wrote a spec script,
Hmm.
and the studio Paramount wants to buy your script. So in the agreement under which Paramount buys Nancy's script that she wrote on spec, um, there will be two kinds of language. There will be language that says that you agree that this was a work for hire, and therefore we, Paramount Pictures, own the script that you created, that you wrote,
Hmm.
because we're giving you X dollars. You agree that you are our employee. You are our employee for these purposes.
Hmm.
Because that's an iffy situation. That is not something that is guaranteed because of what we talked about a minute ago, which is you already wrote the spec script. So now having that agreement after the fact may or may not fly. And so the studios a long time ago figured, okay, somebody is going to get smart enough someday to figure out that this was not really a good work for hire arrangement.
Hmm.
So let's find another way to own what we're paying for. And that is by assignment. I, Nancy Fulton, assign to Paramount the copyright in my script in exchange for payment by Paramount of X dollars. I assign it. I transfer the entire kit and caboodle to Paramount. I assign the copyright.
Hmm.
Okay.
Right.
The problem with assignment for the studios, as they're learning 35 years after the fact,
Yep.
is that you, Nancy, 35 years from the time you signed the contract with Paramount, you can take it back.
Hmm.
There's something called the termination of transfer
Hmm.
that the Copyright Act provides for. So studios would much rather, producers, everybody would much rather have a work for hire arrangement than the assignment arrangement, because the assignment arrangement's only good for 35 years. And 35 years sounds like a long time, but think of Mickey Mouse. It ain't.
Well, not to mention the fact that for Iron Man, as it turns out, it
There you
wasn't
go.
long enough.
And Spider-Man. Well, the original one that Jack tried to get back was Captain America.
Right. So Jack
Okay,
Kirby, so
we settled.
he's
We
glassing
settled
over the
literally
fact.
on the Supreme Court steps.
Right.
We were about to win in the Supreme Court and get Spider-Man back, and Marvel didn't want that. I mean, not Spider-Man, Captain America back, and Marvel didn't want that. So we settled,
Hmm.
literally on the Supreme Court steps. In any event, um,
It's cool.
they don't want the assignment. They want to try to bamboozle people into thinking that the work for hire provisions of the standard agreement with the studios is valid. One of these days, I'm going to get somebody who has the balls and the money to fight the provision that says that it's a work for hire, even though, of course, you wrote the script on spec before they ever bought it from you.
Mhm.
One of these days, I'm going to get somebody who's going to want to fund that litigation, and I'm going to win it.
That sounds like a good time.
And
All right.
that will completely upend Hollywood.
I'll tell you what, I will keep my eyes open for them. I'm sure that that person will cross my desk and I will send them directly to you. I'll go, this is that guy. So, all right. The reason that I wanted to sort of dive into that, because I think it's critical for people to understand. Most of us, who are screenwriters, everybody who's a filmmaker is going to have to acquire the screenplays, and they're going to have the screenplays modified. Everybody who's a writer of a book, if is going to be in a position where you want to have, if you have different editors come on board and they start changing the language, it starts being about them contributing to the work and how much they're contributing.
Okay,
So
so
rules are
the
important.
book business is very different than Hollywood.
Right.
The book business, an author licenses the publisher certain rights, but keeps ownership of the copyright.
Right.
In the book business, the author licenses the publisher to print the book, to publish the book in three forms: printed, electronic, and audio.
Right.
Audiobooks, ebooks, and printed books.
Mm-hmm.
All other rights are reserved by the author in the typical publishing agreement. It's a whole different world. Has nothing or very little to do with how Hollywood works.
No, the only reason I
Hollywood
mentioned
wants
is
to acquire copyrights,
right,
because they want to merchandise the hell out of
right,
the characters, and they want to do everything they can to make to exploit the work in every way possible, streaming it, DVDing it, motion picture theatering it, whatever they're going to do, television, whatever they're going to do with it.
No, my only point was specifically because when, as a writer, I sometimes, if I hire an editor and they're contributing actual words to the document, or alternatively, I'm a person with a story to tell and I hire a ghostwriter. I'm talking about the reasons why people who are writers and people who are screenwriters, as well as filmmakers, all need to understand the work for hire rules. Because if I'm a writer or a person with a story to tell and I hire a ghostwriter, I don't own the story. It's the guy that's writing it down that owns it. So I need to have an agreement with him in order to ensure that the content that he is creating actually does belong to me. So I just want to underline exactly why you need to know about work for hire, because I think a lot of people think they just don't understand what the details are or how important they can be in the long run. If you want to own your story and you're paying somebody to write it for you, you have to have a contract in place. You can't just assume that because you're telling them something and paying it that you own what you're telling them.
Right.
Right. So
that's a good way to say it. Agreed.
So the if so here now we dive into the next big question. So more and more people are creating podcasts. More and more people are doing writing fiction, self-published books that are doing reasonably well. They've found a market or whatever, and they're creating audio books. So now let's talk about if I pay somebody to record or to speak the words of my book, and does the person who's speaking the words, the performer, own the words, or does the author own the words?
The author owns the words. The author owns the words. The actor or the voice person owns nothing. He or she is getting paid a fee to read the book, to narrate the audiobook, and owns nothing.
Unless he the record, unless he's at a home studio and he's pressing the record button, right?
Right. Which is complicated because if you compare it to photography, the person who clicks the shutter on the camera owns the copyright in the photograph,
right?
Not the subject of the photograph,
right?
In the audiobook world, or the well, we'll talk about the music world if we have time later. It's a whole other nightmare. Um, in the audiobook world, it is the words that are being read that are protected by copyright. The
Mhm.
reader owns nothing.
Right. And so, and actually, somebody asked a good question that's related to the topic we just addressed, and I'm going to bring it up here. The Can you copyright an outline or a treatment? And if somebody takes that and turns it and fleshes it out to create a screenplay or to create a book, who owns that?
Okay, so this is what we call, in copyright parlance, the idea expression dichotomy.
Yes.
Okay, copyright protects the expression of an idea. Copyright does not protect an idea itself.
Hmm.
Boy meets girl, boys' parents and girls' parents don't want them to get together.
Hmm.
The basic idea of
Every film on Earth and Romeo and Juliet.
Romeo and Juliet. For those of you who are old enough to remember the movie West Side Story, like Nancy and I remember,
Hmm.
1951,
Hmm.
boy meets girl, boys' parents and girls' parents don't want them to get together, right? Rival gangs
Hmm.
in Harlem, in New York in 1951.
Hmm.
So, if Shakespeare were alive at the time West Side Story was created and released, could he have sued the creators of of West Side Story for copyright?
No.
The answer is no,
Right.
because the only thing that was taken was the idea itself, not the expression of the idea. No characters the same, no dialogue the same, settings not the same, nothing is the same other than the basic theme or idea of boy meets girl, boys' parents and girls' parents don't want them to get together. So the answer to the question about outlines and treatments and synopses, etc., is that they are not protected by copyright other than the words themselves in the outline or in the treatment or in the synopsis. Those are protected by copyright, but registering an outline or a treatment or a synopsis is useless because nobody's going to reproduce or copy your outline or treatment or synopsis. They're going to perhaps take the basic idea of what you've written about in your 3 or 4 paragraph outline and run with it and create an entire screenplay
Hmm.
based on it, which you will not be able to sue for copyright infringement.
Hmm.
So you may ask
Hmm.
yourself, if I can't protect my ideas by way of copyright law, which I cannot, how can I protect my ideas? Mr. Desney, back in 1941, pitched an idea for a movie to the secretary of the producer, Billy Wilder. And pitched the idea, hung up the phone. Secretary said, I'll tell Mr. Wilder about it. If he's interested, he'll call you back. A year later, movie comes out, exactly the idea that was pitched by Mr. Desney. Mr. Desney sues Billy Wilder and says, you stole my idea. And the Court of Appeals in California said, what are we going to do about this? There's no copyright law. There's no infringement of copyright. Nothing was copied. No expression of the idea was copied. So how are we going to compensate Mr. Desney for what happened here? Aha. When Mr. Desney pitched the idea to Billy Wilder's secretary,
Hmm.
there was an implied contract which said, you understand, Mr. Wilder, or Mr. Wilder's secretary on behalf of Mr. Wilder, you understand, I'm shaking hands here, you
Hmm.
understand that if you use the idea I'm about to pitch to you, I expect to be compensated on terms and conditions to be negotiated in good faith within customary entertainment industry parameters. I
Mhm.
don't have to say any of those words. Every time you as a producer go into a pitch meeting with a studio executive, somebody who's going to buy your idea, your
Mhm.
pitch, there is that implied contract. You don't have to shake hands with that person and says, you understand, Mr. or Ms. Executive, that if you use the idea I'm about to tell you, you will compensate me on terms and conditions and good faith. Yeah. You don't have to say those words. It's implied. There's an implied, in fact, contract under the custom and practices of the entertainment industry.
Right.
So that's what the court in Desney versus Wilder came up with.
Mhm.
It also said, in the same opinion, one of my favorite lines:
Mhm.
the law does not protect fools, which means if you get drunk at a party and you meet Steven Spielberg
Mhm.
or some big producer and you blurt out your idea for the movie, and Mr. Spielberg runs with it and creates his next big blockbuster movie based on your idea, you have only yourself to blame. There is no implied, in fact, contract, because this was not within the custom and practices of the entertainment industry. You did not set up a pitch meeting to pitch Mr. Spielberg your idea. You met him at a party and you blurted it out. The
So when
law
people
does not protect fools.
so when people go to Pitch Fest or they go to the
That's an entertainment
competition,
industry event. There is an implied contract. Nobody has to say it. When you go to a pitch fest or whatever, there is an implied contract that if that pitch meeting results in something further, that you're going to be compensated on terms to be negotiated.
even if it's for some of the other attendees who were not, in other words, let's say the person that takes it is not a producer but another screenwriter who hears the idea.
Yeah, that's the problem.
Yes.
So you don't want to blurt your ideas out to the fellow people while you're waiting, to your fellow writers while you were waiting in line. You want to or discuss your idea for whatever it is and your pitch to the acquiring producer or the executive or whatever, but you don't want to pitch it to other writers necessarily.
And when it
You want
comes
to
to
be smart.
and when it co- and I think I've heard you address this before, but I want to touch on it. Should you leave anything in the room, like
No,
a treatment or anything that they can build from?
no. So here's the big problem with all of this stuff.
Hmm.
I forget the plaintiff's name in the Miramax case. I'll think of it in a minute. Guy has a pitch meeting, leaves behind a 30-page treatment, I think it was,
Hmm.
details, scene descriptions, character descriptions, dialogue, beginning, middle, and end of the story. Not a full script, but a lot.
Hmm.
So Miramax ends up making the movie based on this guy's treatment, doesn't pay him, of course. He sues. Miramax argues this is copyright infringement because it is, this is the word that lawyers use is preempted. The federal copyright statute trumps, no pun intended, trumps over the state law on breach of implied contract because there was 30 pages of stuff that this guy left behind at the meeting. And the question is, was that 30 pages copied? Was it the copyright, the right to make copies, which is what copyright protects, was the copyright infringed by the movie based on this 30-page treatment?
Hmm.
Our plaintiff was successful in arguing that copyright law did not preempt and that the case could proceed in state court for breach of the implied contract. The moral of this story is the more elaborate stuff you leave behind, the more likely it is that the studio, the production company, the network, whatever, is going to prevail on this argument that the copyright law protects. So what I advise my clients is, at the very most, you leave one paragraph.
Mhm.
Your name, your address, etc., your contact info, a log line, maybe 3 sentences at most. And therefore, they cannot make the argument that copyright law trumps state law, because copyright infringement would be very, very difficult to prove.
Right.
A movie based on it, even a 30-page detailed treatment, would be very, yes, Christine, one sheet. That's it. Log line and contact info. That's it. That's as most as you want to leave behind when you pitch somebody something.
Right.
Never leave behind a script, never leave behind anything detailed.
Right. So, and while we're here, let's go ahead and just talk 2 seconds about titles. Can a person protect, can a writer or a filmmaker or anybody else protect the title of something? Like if Gone with the Wind, and what if it's something that includes a trademark, like, the Muppets Go to Hollywood, or Darth Vader Conquers the World? There's like,
So you've conflated copyright law and trademark law.
people do
So
that.
copyright does not protect titles.
Mhm.
Trademark law protects the titles of a series of something. So when the first Star Wars movie was released in 1970, whatever, if you look at the symbol after the S in Star Wars, in the upper right corner, you're going to see a little TM, because it was not protected by trademark law because it was the first movie. When the second movie came out, Paramount registered Star Wars as a trademark. And you will see an R in a circle, registered trademark. Trademark law protects a series of something. Harry Potter and the is a trademark. Star Wars is a trademark because there was more than one of them. So when I represent book authors who create a title that is going to be used in a series of books, like Harry Potter and the, I have them register the trademark for it.
Very cool.
But for a single title work, there's no protection, which is why, for example, Wind, Done, Gone, Wrong, or whatever the parody was of Gone with the Wind, no problem, because Gone with the Wind is not protected. There was only one Gone with the Wind.
That's very interesting. Okay, so we have I'm going to go ahead and dive into the next questions. If you're writing under a pen name, do you register the work under your real name or under the pen name? Or what if you have multiple pen names?
Well, the copyright registration form will ask you if you're using a pseudonym. If you are, tell them. You have to put your real name as the author, but you can use a pseudonym if you want to.
Cool. And that will allow
for copyright purposes. Now,
Right.
just to complicate things further, because nothing is ever simple in entertainment law.
Yes.
The Writers Guild, and by the way, the Screen Actors, or SAG-AFTRA, and the DGA all protect the names of their members. For
Really?
example, why do you think Samuel L. Jackson has to use the L?
Because there's a Samuel Jackson?
Right, exactly. So if you come up with a pseudonym, you can't call yourself
Aaron Sorkin?
Aaron Sorkin. Thank you. Good name.
What about Aaron L. Sorkin?
Right. That's what you would have to do.
Although I would not.
If the Writers Guild even let you do that.
Right.
Unlikely. So, but for copyright purposes, you can call yourself whatever you want.
Cool.
Or you can call yourself nothing. You can call yourself anonymous. Which over the years, a number of books have been published by anonymous.
Yeah, that's actually that's interesting, actually. So if a next question I have is, it's really common for filmmakers as well as for writers, etc. If I write an interview, let's say I interview you and I write down your words. Do I own the interview, or do you own the interview? Your words. We sort of talked about this when it came to recording audiobooks. But for people that are uh, writing books where they're incorporating people's testimony and people's dialogue, who owns that?
Depends on the arrangement you and I have made in advance. You're the interviewer and I'm the interviewee.
What if there's no contract?
And the interview is published in question and answer format.
Yes.
You own your questions, I own my answers.
Really? Even though even though you didn't write them down, but because you know
Right.
I was
Right.
writing them down.
Right.
Wow, that's wild. So people should always. So that means that if you're doing interviews with people, you need to make sure that you have an agreement with them as well.
Uh-huh.
Wow. Nobody does that. Nobody knows that. Let's see. The if I am recording an interview as a
Well, interview is going to be published in the newspaper or in a
it's either a
journalistic
documentary
thing?
or a newspaper. Yeah.
Okay.
Two different
Newspaper
things.
can publish it with impunity. No problem.
Okay.
What I thought you were saying was you interview me, you take the interview, and you try to sell copies of the interview.
Right.
Whether it's a documentary, on
Right.
film or in a written form on
Right.
your own. You're an independent writer. You're not an employee of
Right.
the LA Times.
Right.
Then I own my answers, you own your questions.
Right.
If you are working for the LA Times and you're interviewing me because I've done something newsworthy or I have something to say about something newsworthy, then that's a huge exception to what I just said.
Why? Is that because newspress enjoys particular privilege?
Right.
So
and we have the First Amendment.
And if I'm an independent journalist and I sell my work to lots of different publications, is that still the case? Because it's where it gets published. That's the issue, is where it gets published, not who did the creating.
The issue is how it gets published and who publishes it.
And the purpose.
Right.
Right.
All of the above.
So somebody says it's not, somebody's mentioning, is it because one's for profit and one's not for profit? But that's not the issue. It's not a question of profit versus not for profit, because it's newsworthiness. Well, that's interesting. If somebody mentions, let's say I listen to a lecture and like at law school, and somebody hears, or any other place, and you write that down, who owns those notes that you take? Maybe you don't write it down word for word, but you write down the ideas.
You own your notes. The moment you put your pen to paper, you own the copyright in whatever you've written.
So if I'm interviewing you, but I don't write down exactly what you say, that's it. Then I own what.
Then you own the copyright in what you've written. I own the words
I put in your mouth, which is a good rule. I like that. All right. And while we're here, somebody had a question a few seconds ago, and I know it's one of your very favorite topics. You do have to sit back, however. You have,
sorry.
It's all right. One of your favorite things. It's just, you think about it all the time, how much you like it when people put lyrics in their screenplays or in their books or in anything, ever. Do you want to talk for a few minutes about music and then dive into why you should never put anything like that in your work?
So there are two copyrights in music. There is the P in the circle, which stands for phonograph, or phonogram, actually, way back when. And there is the C in a circle. The C in a circle protects the musical composition, the sheet music, the lyrics, and the musical notes on the page. The recorded performance is a separate copyright. That's the phonogram copyright. Lyrics and music and musical notes are just as protected by copyright as any other words on a page are. And so in order to reproduce those lyrics, one must obtain permission from the copyright owner, the composer of the song, or composers of the song. They don't have to give you permission.
Even though let's say you're only using maybe 4 lines of a Beatles song.
I want to hold your hand.
Yeah, like that.
5 words. I wanna, or wanna, if wanna is one word, hold your hand. 5 words.
Mm-hmm.
Or in the case of My Sweet Lord, 3 musical notes.
Wow.
Yeah. There is no minimum.
Mm-hmm.
It's whatever the situation will, whatever argument you can make to convince a judge and a jury that you own the copyright in those 5 words or 3 notes. If I represented Northern Songs, Beatles music publishing company,
Mm-hmm.
and I were to argue that I want to, or She Loves You, Yeah, 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 or any famous Beatles lyric,
Mm-hmm.
it doesn't matter that it's only 5 words. I Want to Hold Your Hand is an iconic lyric.
Mm-hmm.
You know, I don't have to reproduce the rest of the song.
Mm-hmm.
I
And
don't have to
especially
have the yeah, yeah, yeahs and everything else
right.
in the song. All I need to say is I want to hold your hand, and everybody in our generation knows the Beatles, Lennon and McCartney, composers of the song.
Yeah.
So in order to put I want to hold your hand as the lyric sung by a character in your book or sung by a character in your screenplay, I need permission from the Beatles. And the Beatles ain't gonna give it to me.
So
So the bottom line is do not, under any circumstances whatsoever, reproduce lyrics of songs in your book or in your script. Period.
see that I think that's good to know. And somebody's asking, is that true? Even if even if you give the artist credit at the front of the book, so you credit them, so you have a little, like a little footnote.
If you get the only reason you would give them credit is because you have entered into an agreement with them to give them for them to give you permission to reproduce the book, the lyrics.
Right.
You would have to pay them money, and yes, they will also demand appropriate credit.
Right.
As
And
part
so
of the agreement, written agreement that you will have entered into in order to have permission to reproduce the lyric.
right. So even if it says like within the text, Susie was listening to her favorite Beatles song, I Want to Hold Your Hand. Even if you're just saying that she's listening to it.
Uh-huh.
Yeah, no.
Well, that's a little different because you're not reproducing the lyrics, you're using the title of the song.
Right. But let's say, but she's listening to, and then she sang along, whatever, insert 10, 20 lyrics, insert 2 or 3 lines of lyrics here. So the issue, in one case, you're
Yes.
citing the name
Then
of
you
the
would need
song, and the other
permission.
one, you're recording the lyrics of the song.
If you're just referring to a song by its title, no problem. If you're going to start quoting lyrics from the song, big problem.
Right. And so that means, and if you're going to do something crazy like that, you need to have an attorney work with you, because that's going to be a hassle. And
That's the moral of the story, no matter what the situation is. No matter what you're doing, work with an attorney.
Because it's going to be bad otherwise. So, and the other thing that's important to note about that is that, and this is another slight deviation, but important for filmmakers. They talk about clearing title. And in the past, sometimes people think clearing title means, making sure that you're not using a title somebody else has used. That's not what it means, right? They really, like, people, it's confusing, right? The title, so they're making sure that you didn't name your project Gone with the Wind because because of other 3 million films in the world, and that's what clearing title means. That's exactly not what it means. Clearing title means that the work that you have registered at the Copyright Office actually belongs to you, and everything in it is kosher, correct? Or what does that mean?
So let's distinguish between clearing a title and chain of title.
Okay, do that.
What you're talking about is chain of title.
Right.
You have to establish every link in the chain of custody, for lack of a better word, from the originator of the writer of the screenplay to the finished shooting script, from the writer of the first draft of the first script to the final shooting script that's going to be used to make the movie.
Mm-hmm.
If there's more than one writer involved, or if the script is based on something else, a true life story, a book, a magazine article, every link in that chain from the origination to the end result needs to be established. Chain of title. Clearing title means that you've established every link in that chain and the title is cleared for use. clearing titles can also mean, just to confuse you, literally making sure that the title, Gone with the Wind, can be used. So even though I said a while ago that titles of movies and individual books or whatever, individual works are not protected by copyright, titles of movies are not protected per se, but all of the major studios and the major independent distributors are all members of the Motion Picture Alliance. And they have all entered into a gentleman's agreement, which basically says we won't use each other's titles. So, remember the movie The Mask with Jim Carrey? When the movie with Cher and Eric Stoltz came out, Mask. The owner of the studio that owned The Mask, the Jim Carrey movie, got and successfully got permission or an agreement not to make any arguments or make a stink about the Eric Stoltz Cher movie. Even though they, except for the Mask was the only word in the title. So by gentleman's agreement, they've agreed not to use the same or similar titles unless there's permission. So in that case, the argument was nobody's going to confuse the Jim Carrey movie with the Cher Eric Stoltz movie. Two entirely different movies, even though they had the same title. No problem. Go for it. Cher Eric Stoltz movie, no problem. Sometimes it's not so clear. And sometimes the public gets confused. And if the public gets confused, that's a big problem. So that's how titles are cleared, by virtue of the studio before they release the movie, making sure that nobody else has used the same or a similar title. And if they have, they go to the owner of the same or similar title movie and enter into some kind of an arrangement.
Great. So and everybody, before they're if you're producing a film, even if you're an independent producer, you have to go through the process of working with an attorney to clear your film. And this brings up an interesting topic that I just want to segue into. So briefly, so I'm a movie producer. I go and I shoot 60 scenes in my movie. And within the movie, I have establishing shots that I've licensed from different royalty houses. So I have the finished film and I've got the license agreements. How the hell do I register that at the Copyright Office? Do I go and I mention these seconds don't belong? Do I register only the work that I've shot? I don't understand how to
just register the motion picture.
Okay, great. And you don't have to license in there that okay.
You don't have to include the permission that you got from the Heinz Ketchup Company to have your character pour Heinz Ketchup on the French fries. You don't have to include the stock footage of, the plane flying in the sky, even though you've licensed that.
But you have to have licensed it. The point is that if you are using stock footage, you do have to have a license, so that if anybody comes back to you,
you just register the copyright in the motion picture.
Right. Okay, because it's an original work that has
all of the underlying agreements that you used or that you entered into in order to create the finished product are not separately registerable for copyright.
Right, but you should work with an attorney, especially if you've got
have those agreements. Yeah, you got. Yeah. If you want to use stock footage, if you want to use, you want to film in a location where there's a piece of artwork on the wall,
or a statue, the statue thing. That's
or whatever it may be.
Yeah.
You need location agreements, set design, all that stuff. Here's what I tell law students. Every time you see something on the screen, whether it's a credit or something, there's an agreement for it.
Right.
If there's no agreement for it, somebody's in trouble.
Right. Again, people don't understand that when it comes to artwork, people own their statues, just like that they own that bull on in Wall Street. Artists have rights in those things. So if I film a riot, let's say when it comes to news footage or I'm creating content that is based in the real world, if I film something newsworthy happening on a street, I register the copyright for that footage even though it's
Absolutely. You're the filmmaker.
right. And even
You're
though
the
it has,
one with your finger on the shutter, on the movie camera trigger, whatever it's called.
even if I don't
Forgive my
have,
technical ignorance.
even if I don't have the, if again, I'm very specifically saying I'm on a public street or in a public place, I see a riot happening, I film the riot, I don't have the permission of the people, say, rioting.
Of course not, because it's newsworthy.
Right. So it falls into the newsworthy category. Now let's do the same thing. I'm at a conference, like we do events all the time. And let's say I decide to, as the person filming the conference, we're in a private place, and I start capturing the or I'm if somebody's lecturing and I press the button, I don't own, it's a different situation because I don't have their permission
Right,
to, and I could register the copyright, but I have other rights that prevent me from distributing that, correct?
right.
And what is the right that prevents me from distributing that?
Um, you don't have permission from, if I'm the speaker, you don't have permission from me to use what I've said for any other purpose. You infringe my copyright.
Right. So then is it a copyright or is it a right of publicity?
Both.
Both. Well, that's upsetting. So copyright because you've previously created that, or because you haven't fixed it in a
Because I
terrible
said
media?
those words
Really?
and it's being recorded.
That's what makes it, is because you said it. Because so you're
It's fixed
creating it. I
in a
get it.
tangible medium of expression. Those
Right.
words that I've said at our event are being recorded.
Mhm. What if I don't tell you you're being recorded?
Well, you and I have entered into an agreement beforehand saying that you're going to record and that's what's protecting my copyright. So if a member of the audience records me in
Mhm.
your hypothetical and then goes out and sells that
Mhm.
recording, that person has infringed the copyright in my work, which you have kindly fixed in a tangible medium of expression for me.
Oh, very cool. And let's say that I record just while we're here. It's not really copyright. Am I allowed to record people without their knowing me? Let's say that I like gotcha journalism. Am I allowed to record people that are on the phone when they can't see me recording? Am I allowed to record people that are committing? Like, what are the rules about recording people without their permission?
Phone calls, you have to get the other side, the other end of the conversation permission to record here in California. Some other states, no. California, yes. Recording something or filming something as it's happening, no problem.
Great. And if I'm transcribing it, like writing it down, is that a different situation or the same?
Same issues.
Same issues. Okay, cool. So let's see. We talked about chain of title. Um, so this is
Let's
kind
talk
of,
about joint working with
actually
somebody
that's a good
else.
idea. Let's say you have two writers that I have a best friend and we started writing something and we're writing it together, and then what happens?
Okay, so the Copyright Act calls this a work of joint, capital J, authorship, capital A.
Mm-hmm.
If there's a work of joint authorship, there has to be an intent by both parties going into the equation, by both parties, that yes, we're working together. The end result of what we're creating together, we're going to own together.
Mm-hmm.
A work of joint authorship.
Right.
Here's the flaw with the Copyright Act,
Mm-hmm.
in my opinion. The Copyright Act provides that for a work of joint author, either one of the joint authors can sell the work without their permission, without the consent, without even the knowledge of the other joint author.
Mm-hmm.
As long as the proceeds of the sale made by one joint author is split 50-50 with the other joint author, the silent joint author, the one who doesn't make the deal, has nothing to say about it.
Mm-hmm.
So if you and I are joint authors,
Does it preclude him from
you
being
can make the world's worst deal. You
right?
could sell our blood, sweat, and tears for $1.
Mhm.
And as long as you give me 50 cents when you receive that dollar, there's nothing I can do about it.
Can
That's
I
what the
al can
copyright
you
act says.
also sell it as well? In other words, it's not a unique
Yes, and
right,
I can also sell it for a dollar and give you the 50 cents.
and this
And
becomes a
there's nothing
problem,
you can say about it.
and when
And we can both sell it.
yes, that's what I'm saying.
Yeah,
That's a
we can both sell it. And that's why that's a huge flaw and problem with the Copyright Act.
right.
Because, and first of all, nobody's going to buy something on a non-exclusive
I don't know
basis.
if you say that, but if J.K. Rowling's had a writing partner and you could and I personally could get the buy the second copyright, so I and she if she and I could both sell copyrights to different publishers, they could have warring versions of the book, and it's kind of a crazy situation. But the
Which
point
is
is the
why
rights are
nobody's going to
equal.
buy a non-exclusive.
Right,
Right.
right.
So, in order to avoid all of this,
Hmm.
what I have writers do when they collaborate with each other is enter into a collaboration agreement which says that neither of us can sell the work without the permission of the other, without both of us signing the deal with the third party.
Hmm. And
Avoid all.
and then what happens when one of us dies?
Yes, we can. There's a number of ways of dealing with death. One is I go off on my own. I finish whatever it is. You've died, and I go off on my own, and I finish whatever it is that we've been writing together. And as long as I give your estate one half of the money or some percentage of the money that's to be agreed upon. Let's say you die, a week before we're finished. That's one thing. Versus if you die a week after we get started, you're probably not entitled to your estate's probably not entitled to 50%. Your estate's probably entitled to 20% or some number less than 50.
But you need to have that
We'll work
all
it
in
out.
writing. You need to have
We'll
it in
work it out.
the
Or
mhm,
we could provide that no matter what, the estate gets 50-50. Or we could provide that the estate gets nothing.
mhm,
And I have the right to go on to work with somebody else if I want to,
right.
once you're dead or incapacitated or no longer cooperating with me.
Right.
If we have a falling out, I can go off on my own and continue with somebody else.
Right.
Or I can go off on my own, or I can continue with somebody else.
Is there a rule that says if you have to make a positive statement to transfer copyright or license content? It's not enough to have
It has to
like
be
a
in
handshake
writing.
deal. It has to be in writing and it has to be
In
documented.
writing.
So it's not I can't say and it has to be in exchange for meaningful goods, right? It has to be an actual
Consideration, yes.
so I can't say, well, Johnny, when I was working with him, he said this one time that, we would only sell the work together. And now that he's dead, um, I'm gonna
That's
go ahead
why we
and sell
want
it.
a written agreement. So
Right.
the executors of your estate
Hmm.
know what the deal was.
Right. So if there's but if
That's another huge reason to have a written collaboration agreement anytime two people are collaborating on creating something. A lyricist and a musical composer, a, uh, a sculptor of an elaborate piece that's going to get installed at a office building or whatever, where there's more than anytime two or more people are working together on creating something protected by copyright. I strongly encourage them to have a written agreement. And
cool.
here's the third reason that you want a written collaboration agreement.
Hmm.
Read.
Hmm.
If we don't have a written collaboration agreement and there's $1 million on the table, you know what's going to happen? I'm going to come to you and say, hey, Nancy, don't you remember our deal was 70-30?
Right.
And you're going to start yelling and screaming, and you're going to pull out the written piece of paper that you and I had signed way back when, and you're going to say, you see, paragraph 3, 50-50.
Right. So
You lose.
I'm gonna translate in one more second. I'm gonna
As
translate.
my wife would say, if it ain't in writing, it doesn't exist. And writing
Mhm.
in terms of what lawyers think about as a writing, means words on a page
Paper
with a line with an ink signature
and a date.
and a date. Well, a date's helpful, but not essential. Ink signatures on paper, a writing, capital W. That's what we want.
So if I'm going to transfer to asking the question, some of the questions that have gone through chat in just 1 second, but I want to, there's a very specific situation that I've seen happen a lot of times. And a long time ago, kind of happened to me. Um, and I think it's a very common situation, which is I, as a new screenwriter, end up meeting a producer. The producer says, I'm really interested in this project. If you were to make these changes and these changes and these changes, I might decide to buy it. In other words, they kind of do soft development. Now, when this happens, they've been contributing ideas, they've been saying things, but you're the only one that's actually put anything on paper. Question becomes, do I actually own this thing or do they? Because a lot of times I don't think they know. I think they own it because they contributed ideas. But you're the one who actually recorded, you actually wrote stuff. They just said, make this character Asian and make this character a woman. And also change this, change this dialogue so it's more peppy. So
change the setting from Atlanta, Georgia to Jacksonville, Mississippi, or what? Yeah, whatever. Yes, they don't own anything. You own it. You wrote it. You expressed the idea.
Right.
Contributing ideas is not worth anything. Ideas are as free as the air.
So so many people need to understand is, and you as a producer need to understand that when you are talking to a screenwriter and you're giving them
the only way for a producer to own anything written by a writer is to enter into an agreement, written agreement with the writer.
They don't become a joint author by contributing at some point.
No.
Great. So there's a couple of great questions we've had going through. We've answered sort of a lot of them. Judy says, so an email or a text message doesn't count for anything as proof of court when you're talking about transferring
title. An email is a memorialization of an oral agreement. So in contract law, there are two kinds of agreements. There's a written agreement, which is a writing, as I've defined it already, something in writing with ink signatures on the page signed by both parties. That is a written agreement. Anything else is an oral agreement. Problem with oral agreements is they're not worth the paper they're printed on. They're difficult to prove because it's the he said, she said situation. And an email serves as a memorialization of whatever he said and she said. So it is not a writing, but it is evidence of the oral agreement between the parties.
But again, oral agreements are not sufficient to transfer copyright or to transfer ownership in a work.
Correct. There are certain kinds of transfers that must occur in writing. Buying and selling real property, real estate, homes, buildings, whatever, land, has to be in writing. Transfers of copyright must be in writing. Signatures, as I see Judy Bell is asking about digital. California has a statute that kind of says sort of maybe we'll see that you can sign electronically. Nobody's tested it yet. I still am old fashioned. I like ink on paper. I don't mind if it's scanned. So you can take the paper, the physical paper, sign it and scan it as a PDF. Probably still creates it certainly creates a written agreement, whether it's an original or a copy. It's rules of evidence we don't need to get into. Signing electronically, we're not there yet.
Right. So
my recommendation would be use ink. I like blue ink because we can see what's an original.
Right. That totally makes sense, actually. Does a implied contract provide protection to a 5-page synopsis of a reality show or a proposal submitted on a website?
No.
Right. I didn't think so. Let's see. So if I've
While you're
written
looking, go
if I
ahead.
if I've written a screenplay based upon living people, is that a problem? And then what if they're dead?
Okay. So the life story rights is a whole different area of law that we're not going to talk about tonight. This is a
Actually, we're going to
question.
talk about it next. Like we have in about 2 weeks, is it? We have another event where we're talking specifically about options agreements, life rights agreements, and
Exactly. So we're
management
not going to get
agreements.
into that tonight, but I can very briefly, the right of life story rights are based on the rights of privacy and the rights of defamation,
Mhm.
or the law of defamation, I should say. And you can't defame the dead in the United States. So if they're dead people, you can do what you want. For live people, get an agreement with them.
Cool. Also, but keep in mind, if dead people have living people, don't defame them. You get in trouble. Right? I mean, that's kind of the thing. Make sure
Yeah,
they're
we'll talk
buried.
about that more next month.
That's a big topic actually. It's because you can't do biopics. So, what about somebody can? What if I recreate the idea of Spider-Man as long as I use different words? Can I recreate Spider-Man or recreate the Marvel characters or X-Men as long as I use different words? I don't call them X-Men. And like, how close can you get when you're copying?
Battlestar Galactica versus Star Wars.
Mhm.
Same. That's what you're asking about.
Right. Exactly.
You know, when does X infringe Y?
Right.
Substantial similarity. In order to prove copyright infringement, one must prove two things:
Hmm.
that the infringer had access to the infringed material, not an issue in the case of
Hmm.
Spider-Man already being published,
Hmm.
but a huge issue most of the time
Hmm.
when it comes to they ripped me off.
Hmm.
They took my script and made a movie.
Hmm.
Um, how did they get access to your script in the first place?
Hmm.
Usually, most people will kind of pause when I ask them that question. They
Hmm.
say, no access, no claim.
Hmm.
But 70% of the time, when I get approached by people who think they've been ripped off, I'll give you a quick one. Loki from Maldemar was
Hmm.
about a alien who crash landed on Earth and wanted to go home.
Hmm.
Screenplay written by a woman in North Dakota who had never been to Hollywood, never mind had met um, the creators of E.T.
Hmm.
She goes to the movie theater, she sees E.T., and she says, I've been ripped off.
Hmm.
They took my script and they made E.T. No access, and certainly no substantial similarity. No Reese's Pieces, no character flying over the moon or driving over the moon on a bicycle, no ET, no finger. None of that is in Loki from Maldemar.
Hmm.
Not substantially similar by any stretch of the imagination. She sues nonetheless.
Hmm.
She loses.
That's what happens. So if somebody's writing from Canada, when they register their work, can they register their work at the U.S. Copyright Office?
Only if it's been published in the United States.
And they can.
Published means circulating copies to the public.
So let's say that they decide to go online and register through KDP. Sorry, publish through kdp.amazon.com, and they publish in the United States. Then they can
Yes,
register.
then yes, absolutely, you can register your work. And we are members of the Universal Copyright Convention. So if it's first published in Canada, we will give protection to works first published in Canada when they're published in the United States as well,
That's
and
very.
vice versa.
That's cool. So somebody said many screenwriters, like Tarantino, for example, say they borrow from every film they've ever seen, but that's not infringement. So
Yeah,
being part of this, paying attention to the zeitgeist isn't the same as stealing necessarily.
correct.
Um,
Infringing.
right. Cool. So I'm gonna just downstairs here at the bottom. All right. So can you talk?
What should I'm gonna
Yeah.
ask myself one question on your list, if you
Yes.
don't mind.
Please do.
What should creatives do when they believe their rights have been violated? You
I'm
know,
gonna.
the I see these commercials on
Mhm.
TV. Call Jacob.
Yeah.
So the answer is call me.
Yes.
That's what
And
they
actually,
should do when they think their rights have been violated.
and also
Call
before
me.
that. So and actually, you didn't. The other somehow or other we don't really. How can the introduction not be done correctly when we are both doing it and have both done it so many times? Is one of us a litigator as well as somebody who actually does entertainment contract law?
Yes, I do both.
Right. So whenever if you think your rights have been violated, you need to work with a litigator for a particular reason. And what would that be? As opposed to somebody that just does business contract law.
Because you need to be able to be prepared to sue if you can't resolve the dispute.
Right.
You need to be able to go to court.
Right. Cool. So if how do people reach out to you if so first of all, should people reach out to you in email or via telephone if they have
Either one.
specific questions? Or
Email, telephone, or carrier pigeon. Any way will work. And I
okay.
put at the very beginning of the chat, before we got started, I put my email address and my phone number in there.
Right. And I just posted it again.
There
If
we go.
and I'm going to go ahead with your permission. I'm going to turn this into a video and I'll send you over a copy of it to review, and then I'll make it available to folks going forward. And also just to make sure there's nobody else that sent a message that did not and no other questions that we got this the very last second. Cool.
You got 56 chat things here. Wow.
I know we're busy. This is like, I'm very fortunate in the folks that choose to work with me. So I think we've pretty much gone through all of the questions. I do heartily recommend that you reach out to Paul if you have questions. And okay, and particularly like Craig, you're asking a question, if you're working on a short film and somebody is willing to invest money, et cetera, et cetera, et cetera, that kind of a question is so complex and is so specific to that particular project, and the devil would be in the details. So you need to reach out to Paul directly and ask that question, because it's too complex and it's not really about copyright specifically, or about other intellectual property rights.
And I also saw a question about collaboration agreements. What happens if you have disputes or whatever?
Yeah.
That's yet another reason to what happens if one person changes something that the other person doesn't like. That's all needs to be put into the collaboration agreement. That's why I charge 2 hours. I'm at $500 an hour. I charge 2 hours of my time to do a typical collaboration agreement, because it's not necessarily a cookie cutter thing that I can cut and paste from one to the other. Each situation ends up being different regarding who's going to do what happens if there's a dispute, how the money's going to get split, etc. Each one is crafted individually.
Well, especially because I think a lot of times people don't realize even that if you're married and you get divorced, that's a thing. And if you die, that's a thing. I mean, there's all these issues that go along.
The way I got into doing family law years and years and years ago, divorces, is I got called by a lawyer saying, I represent two book authors. We need to figure out who owns what.
Right.
How
Exactly.
the community property is going to get split.
Right.
I said, well, did they have a written agreement going? No. So I got hired by divorce lawyers to consult with them on division of community property. And then I said, you know what? I should be representing these screenwriters in their divorces. So now I do divorces too.
Right. So, and then that actually brings up the question, how the other thing about the intellectual property copyright, we didn't ever mention exactly how long it lasts. And I think if people understood that, they would understand why these agreements are so important to
copyright. The term of copyright is the life of the author plus 70 years.
So that's a long time.
But remember, if the copyright is transferred, the transferor can get it back 35 years after the transfer.
And if I've done if a corporation creates content, like Disney has
90 years.
Yeah. So this is a very
from the date of publication.
So
when a non-human being owns the copyright in a work, the term is 90 years from the date of publication.
Right. So
rather than the life of the author plus 70.
So copyright is really long lasting. It's like it lives
really,
longer
but
than people do.
It ends at some point.
Right.
So Mickey Mouse's copyright's going to end pretty soon.
Ha, that's what you say.
So the original term was 75 or 50 years, life of the author plus 50 years, or for non-human beings, 75 years. So a number of years ago, Disney got panicked thinking that Mickey Mouse was going to go into the public domain. And so they arranged for Sonny Bono of Sonny and Cher fame, who was a senator for a brief period of time, to sponsor the Sonny Bono Copyright Extension Act, which ultimately got passed by Congress. And that's why we're at life of the author plus 70 or 90 years. That's about to come up in the next few years. So we'll see what Disney does to extend the copyright on Mickey Mouse even further.
But the point is, these are lifetime decisions. So that's another reason people a lot of times feel like, well, they'll just wing it on the copyright thing or on these agreements, but they can have very long-term consequences. So if you have any questions, once again, do reach out to Paul, and you can find his website at paulslevine.com. And if you have any questions, you can always reach out to me at nancy@nancyfultonmeetups.com. I'm going to go ahead and turn this into a recorded video. I'll make it available for you to review and approve, Paul. And then with your permission, I'll distribute it to other folks going forward. And then just so people get a good.
Oh, but we're going to have a written agreement for you to do that.
Okay, fine. Whatever you say.
I'm just teasing.
Actually, if you put something in front of me, I'm just going to sign it. It's like, okay, I think since you actually are my entertainment attorney, I think that's probably a pretty good idea. Cool. I thank you very much for taking the time to spend time with me. It's very important.
And thank you for having me. This has been great.
And I think the next event that we're going to be doing, where we're talking about option agreements, life rights agreements, and management agreements,
shopping agreements, etc. That'll be a fun one too.
It's going to be critical. I think it's critical.
Hope to see you all there. All 43 of you.
Well, I'll talk to you later, man.
Take care.
Bye, you guys.